first off, let's start with your reaction to these comments from Del Rahim this week. It really seems like he laid out the case for this antitrust scrutiny.
Well, I don't really think you can read too much into his speech in terms of the likelihood of an enforcement action brought by the Justice Department. I think the principal messages he was trying to make in that speech were, one, the cop is on the beat, we're looking at it, and two, we have all the tools we need. We don't need outside interference, and we don't need new legislation.
Now, he also did cite the antitrust case, the investigation against Microsoft, which you personally were involved in. How did that play out? How did that set the stage for what we're seeing in terms of this more critical lens on tech today? And if he were to consult with you, how would you advise him based on that experience?
Well, I would certainly advise him first and foremost to make sure he's investigated the facts and understands them thoroughly. I think Mr. Del Rahim correctly noted that the Microsoft case demonstrates the suitability of the antitrust toolkit for dealing with matters of technology in the digital age, for addressing businesses with network effects such as those we find in the digital platforms, and for bringing antitrust cases even with respect to products that are nominally given away for free. So in that respect, I think the Microsoft case is an important precedent, and he was correct to emphasize that.
Doug, is it odd that all of these companies, Apple, Google, Facebook, Amazon, you can count some others, are being scrutinized at the same time when their business models are so different? And it's not illegal just to be big.
No, it is not illegal just to be big. A violation requires proof of anti-competitive conduct. I think there's a broad populist sentiment in the country, a concern about private aggregations of power that's exacerbated by the tech platforms because they have seemingly boundless capacity to grow by network effects and scale economies because they're newfangled and invisible technology. And perhaps most important, because they implicate other values such as privacy and sort of communications and political community. So it's not surprising that there would be a hard look at those platforms, each of which in its own way has been an aggressive competitor and does seem to have a considerable market clout.
Doug, you say if there is a solution, it's probably in sector-based regulation. Is your argument that we're living more in an FTC world than a DOJ world on this?
Well, I'm not sure that I mean that the only solution is in sectoral regulation. I do think that Mr. Del Rahim is right that the antitrust toolkit is sufficient conceptually. The problem with antitrust law as a tool to deal with some of the issues raised by the technology platforms is that those sound concepts have been construed in some cases to make some rather conservative legal principles and to put a high burden of proof on the plaintiff. So in order to make antitrust enforcement effective, I think you'd have to have both enforcement agencies that are willing to sort of push the edges a little bit and judges that are willing to listen to new arguments. Failing that, some kind of sectoral regulation might be the most effective tool if one believes there are problems that need to be addressed. I'm not sure the FCC is the right agency for that. Some, as you know, have proposed the creation of a new agency or the creation of new regulatory authorities, perhaps for existing agencies.